To accept your submission, we'll have to postulate that clause 3 becomes a sort of a constitutional article which falls into desuetude after 7 years.
Yes, absolutely. Because
How can that be?
Well,
Clause 3 still continues to survive. The limitation on clause 3 may cease to operate.
kindly see 369.
See, 371 begins with a non-obstante clause. It overrides the entirety of the Constitution.
Absolutely.
But clause 3 contains a non-obstante clause which overrides clause 1 as well.
Yes.
So therefore, notwithstanding, because 371 makes special provisions in relation to the state of Jammu and Kashmir.
Correct.
But 373 has a non-obstante provision which overrides the non-obstante clause in clause 1.
For that period, we are not disputing that. What your lordships is putting to me, there is a structure in place that was envisaged by the Constitution in 1950. At that time, there was no Constituent Assembly. Why did they mention Constituent Assembly? Need not have mentioned it. Kindly look at it from that point of view. What was the reason to mention Constituent Assembly in 370 when it was not even in place? They could have said Government of Jammu and Kashmir. Why did the Constitution makers include the term Constituent Assembly in 3? Because they knew that the Constituent Assembly will frame a constitution.
Really, there was no limited. The acceptance of sovereignty of the Dominion of India was complete. They didn't say in the instrument of accession that we accept the sovereignty of the Union of India for some limited purposes. They accepted the sovereignty for all intents and purposes. That acceptance of sovereignty was complete, but they reserved certain rights to themselves over certain legislative subjects. So in that sense, the accession was complete. The acceptance of sovereignty was complete. Now, consistent with that, therefore, it said that in clause 3, that the Union of India would have, the President of India would have the right to abrogate Article 370. It conditioned that subject to
not the Union of India, but it's on the recommendation of the Constituent Assembly. Not Union of India has no right to till that is recommended. The word is recommendation of the Constituent Assembly. Then they can exercise that right. That's how you interpret a proviso. You can't say that they have the right sovereign, forget the proviso, even the recommendation of the Constituent Assembly, because it doesn't exist. Then 368 2 proviso also goes, Maras. Therefore, the reason is simple, Maras. The genesis of it was the fact that in 370 itself, it was mentioned that the Constituent Assembly has a role to play in the abrogation of 370. Otherwise, if your lordship says it had no role to play, there was no need for 370 sub-article 3. And look at the concurrence power. Even those powers were of no relevance thereafter because the Constitution of Jammu and Kashmir was in place. Therefore, there was no need for concurrence anymore because now you have a Constitution of the Jammu and Kashmir. So that also became ocious. You have to see, the historical perspective in the context of which Jammu and Kashmir ultimately signed the instrument of accession. Nobody disputes whether they are integrated into India, but subjected to a constitutional provision.
Therefore, the submission is that once the period stipulated in the proviso to clause 3 had come to an end,
yes, the
power under clause 3 itself came to an end.
Because it's no longer alive. The Constituent Assembly, like in India, can, for example, today, there can't be a provision in the Constitution of India with reference to a Constituent Assembly because the Constituent Assembly has worked itself out. It has formed the Constitution. Now, if it is decided that they would abrogate 370, the Constituent Assembly would have said, we abrogate 370, which is why it was a temporary provision. Not because of the fact that under as a Union of India, it was deemed to be a temporary. How could it be?
Sorry, interrupting you at this stage. It does maybe just putting a question.
Sure.
I'm not. If one looks at Article 370, clause 1B.
1B, yes.
The first proviso, provided that no such order which relates to the matter specified in the instrument of accession of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of the state.
Correct.
So the second proviso talks about concurrence of the government.
Yes.
Now, if one looks at clause 2,
yes,
it deals with a situation where the assembly or the government of the state is not there. It deals with the period when the constitutional assembly of the state was in existence, but the government or the elected assembly was not in existence. And therefore, the proviso to clause 3 will only be applicable as long as the government of the state or the assembly is not elected. Because election of the assembly will take place after the constitutional assembly of the constitutional assembly of the state of Jammu and Kashmir enacts the constitution.
Government was always in place from day one.
No, maybe so.
Government is always
Because
in place from day one.
that appears to be the broad outline of this, outline of Article 370. What Clause 2, when it refers to the Constitutional Assembly of the state, it is for the purpose of for framing the Constitution of the state, which shall be placed before the Assembly for such decision as may be taken thereon.
Correct.
So the Constitutional Assembly of the state makes the Constitution, frames the Constitution, it goes before the Constitution.
No, it can state in the Constitution that the 370 is abrogated. What problems are there? It has the power. That's why there is a Constituent Assembly. And it says, notwithstanding anything in the foregoing provisions, kindly note that. Notwithstanding 37(1)(b)(1) and 37(2), notwithstanding any of that. So, you start the article by saying notwithstanding anything in this constitution, and 3 starts with notwithstanding anything in the foregoing provisions. That is notwithstanding the opening part of the article also. There was a government. Yes.
Assistant of Constituent Assembly of the state.
Yes.
If sub-article 3,
Yes.
according to you,
Yes.
has become non-existent, ceased to operative,
Yes.
then how the very temporary nature of Article 370 will survive?
That's why, because it's temporary, because the Constituent Assembly had not been framed, but at that point in time had not been constituted. In 1950, when this provision was added in the Constitution.
No, if sub-article 3 goes, then that means Article 370 can never be abrogated.
Yes, that's the whole point, Mullah. That is our case.
Then how it is temporary?
It is temporary because when this article was framed, Mullah, there was no Constituent Assembly. It was the Constituent Assembly which could have taken the decision that we will abrogate 370 and merge completely with the Union of India like any other state.
Mr. Sibal, your contention, if I've understood you correctly, is that the temporary nature of 370 is correlatable to the
Constituent Assembly.
Life.
That's my
And
argument.
in a way, subclause 3 becomes otious once the Constituent Assembly ceases to exist. This is your contention.
My contention.
From 51 to 57, it is temporary.
Your lordships of the Constituent Assembly, they say the same thing. Mr. Iyengar, they say the same thing. What I am saying, Mullah.
I'm just trying to phrase it as I understand
I-
it. I'm clear
Your
that
lordships have understood it, and I also understand your lordships, what your lordships are thinking, Mullah. So I have to respond to that.
According to it, is temporary between 51 to 57.
That's correct.
And thereafter permanent.
The reason is simple, Mullah. All Constituent Assemblies are temporary. There is no permanence in a Constituent Assembly. So when you
Role is limited to framing the Constitution.
Yes. Therefore, Mullah, if it is temporary by its nature, which is why I started by saying this is a political exercise. That's why I, Mullah, started with that summation before your lordships. The formation of a Constituent Assembly is a political exercise to ensure that people within the territory of a particular region, their aspirations are taken into account to formulate a law and a constitution to ensure that those aspirations are met in future times to come. It's not a law-making exercise. Then they framed the constitution to take into account those aspirations. That's how our republic came into force. Because there was the 1935 Act, there was diversity. But let's kindly look at it historically. Let's not forget the law for the moment. Look at it historically. If you look at Europe and the making of the nation states in Europe, how did that happen? It happened because there were large empires, the Austro-Hungarian Empire, Prussian Empire. And whereas those large empires had communities and within those empires, there were peoples of different languages, of different cultures, of different ethnic lot. So it is the breakup of the empire that led to the rise of the nation state, the Treaty of Utrecht, the 1848 revolutions, right? In India, the process was the opposite. It's the only exception. The process was just the opposite. There was disparity. There were existing disparities. There were 562 princely states. There were states, which were part of the British Crown. They had to be amalgamated. And each of them had certain conditions. But then ultimately they all agreed, okay, for the states that were part of 562, all agreed. But this particular state of Jammu and Kashmir was an exception. And the exception was constitutionally engrafted in Article 370. And the terms of the exception were constitutionally engrafted in 370. You can't jettison the people of the state of Jammu and Kashmir and decide that then what's the difference between this and the Act of the Crown? What's the difference between this and the annexation of Junagadh or the annexation of Hyderabad? Then it's an act of paramountcy that I am the union and I will decide. When you have constitutionally committed yourself that if this is to be done, you have to follow a process which two sovereign authorities have agreed upon and engrafted in Article 370. Otherwise, then it's exercise of paramount power.
In the assimilative exercise carried out, your submission, as I understand, is J&K is an exception because a temporary provision was created for a period of time, and after that it is engrafted permanently into the Constitution.
Because you can't revive the Constituent Assembly.
I'm just saying, what is that?
That's what my submission. I appreciate, your lordships have fully understood what I'm trying to say. What is it that you have a state of Jammu and Kashmir with today 14 million people. At that time, they were much less. They have no role to play in their own fate. If in 1950 it was part of the union, there would be no issue. The aspirations, the desires of the people, whatever it is, after all, this was something that also had international repercussions at that point in time.
If an elected assembly would want to abrogate 370, even that is not possible.
Not possible. Not possible. That is why they had to do these things in the manner that they did.
But the only way we can reach to that conclusion is by saying that once the period for the work of the Constituent Assembly of the state comes to an end, then what is essentially a temporary provision assumes a permanent character in the Constitution.
But that, yes, not to be that.
But if that hypothesis is not accepted, then the only basis on which you can really, place your petitions here is that by asserting that a pre-constitution compact, which was entered into between an independent state and a state in which it has merged, so to speak, is enforceable, irrespective of what the legislative power of the merging state is.
Because the legislative power, both of the parliament here, cannot override the powers under 356 of the Constitution. Because what has been used is 356. There is no such power under 356 that can take over.
Can an independent state, which accepts the sovereignty of another state unconditionally, still say that, if the parliament of that state to which we have assumed the sovereignty of is still restrained in terms of the original compact?
It's unconditional, It's unconditional. And apart from, forget about that. Can Parliament of India, Parliament of India, in the context of its responsibilities and powers under the Constitution of India, do an act beyond 356? Can't. There are very complex issues that your lordships will have to decide. This power is exercised under 356. How is that can be exercised under 356? 356 itself is a temporary power. What are you trying to say to me?
Well, what you are saying, you see, which means even, let us say, a hypothesis that the will of the people is to abrogate it.
Yes.
Which is reflected by an assembly elected.
Yes.
You are saying even that scenario, it cannot be done. Trying to understand the consecutor would be, even then it can't be done.
But that would be a political act then, I would say that if that situation arises, it would be a political act.